Let's now bring in our first guest today. We have former Integrated Bar of the Philippines President Atty. Domingo Cayosa. Attorney, welcome to the program. Thanks for joining us again.
Morning, Angelo and Angela. Magandang umaga sa inyong tagapagkinig at nanonood sa inyo.
Opo, attorney, siguro po what to expect in 6 months before Duterte's ICC pre-trial or yung confirmation of charges?
Well, we expect the process to unfold. The prosecution will have to show the defense yung mga ebidensya, mga testigo nila, and then so that the defense can properly prepare for the initial trial. Secondly, it's also possible that the defense is preparing pleadings, questioning the arrest, questioning the jurisdiction of the ICC, and perhaps asking for provisional liberty.
Yes, attorney, a while ago, I don't think if you heard the soundbite of Attorney Cristina Conti, sabi niya zero probability daw ang for interim release for the cases that is being charged against former president. What are your thoughts on this statement?
But we cannot and we should not preempt the ICC. But basing on what is happening on the ground and the purpose for and basis for provisional liberty, medyo malabo nga. Sapagkat an accused is granted by the court provisional liberty as long as there are solid grounds for them, especially that the accused will come back and face trial. Sa ICC, bawal yung trial in absentia.
Yes.
Pero dito sa mga pangyayari na kung saan malinaw yung mga sinasabi ng mga kapartido niya at mga kakampi niya na dapat sa Pilipinas siya, dapat korte sa Pilipinas ang maglilitis, talagang wala silang balak bumalik sa The Hague. So it will be foolhardy for the ICC to grant him provisional liberty. Also because even up to now, yung risk of flight is very real. So in all probabilities, no court would allow suspect in its custody to escape and easily hoodwink the court to allow him temporary liberty tapos hindi na siya babalik. So from indications, medyo
malabo. Attorney, for reference lang, usually ba pag nag-interim release granted, are they allowed to go home to their country of origin or within the within the area?
Well, usually they play safe dun lang sa area, but there have been instances where the ICC allowed the accused to go home. In one particular case, and I think they learned the lessons from this, one warlord in Africa, in a country in Africa, na akusado din sa crimes against humanity and war crimes, pinauwi. Pagdating sa kanilang bansa, nawala o pinagpapatay lahat yung mga witnesses kasi nga ma-influensya pa rin sila. So, in that particular case, I suppose the ICC has learned its lessons. They would rather keep him, grant him perhaps, if ever, temporary liberty, but he stays in the Netherlands.
Within the within the premises pa rin. Pero if the interim release is not granted, attorney, a possibility that Duterte can seek yung ang tawag dito to drop the case outright by arguing that ICC has no jurisdiction. Kasi sabi po nila noong July 2023, yung appeals chamber, they moved to continue the case outright without talking about jurisdiction.
Well, they can still raise that, and I think that will be a proper time for them to raise the issue of jurisdiction. But if you again look at the previous rulings of the pre-trial chamber and the ICC, they have already ruled by a majority vote that they have jurisdiction. So it will take new evidence, new arguments, perhaps, for the ICC to say eventually they don't have any jurisdiction. So much has happened already, and they are already geared for trial.
Sa panig naman po ng prosecution, ano naman po ina-expect natin sa kanila in preparation for this pre-trial?
Well, we expect them, I suppose, and from the way the ICC has issued the warrant of arrest, they've already submitted sufficient evidence to show that the crimes against humanity happened in the country because they were extrajudicially killing the suspects, and that the former president was involved in it as an indirect co-perpetrator. So the court was already convinced with that initial salvo of evidence for them to say there's reasonable ground to believe that the crime was committed, and that the accused or the subject of the warrant of arrest, President Duterte, is involved. But they have to level up the evidence that they have to make it proof beyond reasonable doubt.
Pero
Also possible
Yes.
that now that Duterte has been ex-President Duterte has been arrested, it's also possible that there will be more witnesses, and perhaps some members of the PNP, and the Davao Death Squad, meron na silang dalawa.
Yes, that's right.
The PNP might be convinced to tell the truth, and we don't know what the government of the Republic of the Philippines will do if they request to subpoena records of the PNP. Kasi hawak ng PNP yung mga records, yung mga natukhang hindi lang nila dinalabas.
Attorney, I'd like to ask also, specifically kasi si former President Rodrigo Duterte had several statements sa Quadcom. He also had statements as a president directing kill. There was a
mga sound bites.
may sound bites na release a few days ago again saying pilitin yung maglaban, and then later on may retraction saying it was all in jest. Could these statements and sound bites and sound clips be used given na urong sulong, may mga sound bites din na dinideny niya na sabi niya joke lang naman. So how would the ICC then take this into consideration?
Well, those sound bites are material and relevant evidence. They were given extrajudicially, out of court, freely and in public.
Yes.
So they are not inadmissible. They are admissible evidence, and they can be, though they may not prove the actual killing, they could be corroborative evidence to discuss yung kanyang indirect participation. The other evidence that would be very weighty is the fact that as President of the Republic of the Philippines and Commander-in-Chief of the Uniformed Services, nung nangyayari yung mga tukhang, wala siyang sinabing ihinto yan. And there was no serious prosecution of those who were suspected of involved in EJK. So that's another thing. There are two things that are relevant: his action in goading or encouraging the extrajudicial killing, and the other one is he was in control of government. He was in control as mayor of Davao and as Republic of the Philippines president, yet he did nothing to stop the massive extrajudicial killings. He did nothing to seriously investigate, prosecute, and hold accountable those who are suspected of having done the EJK. So, all of these mga ebidensya, they'll all be put together, and that's the challenge for the prosecution.
Oo. Taking off from Diego's question po kanina, kasi the first and last appearance of FPRRD sa Quadcom hearing, marami po siya yun nga po sinabi doon na talagang would probably implicate her. Pero ang sinabi naman po kasi ng mga taga-Quadcom, hindi po sila makiko-coordinate with the ICC regarding this investigation. But yung mga sinabi po niya doon and yung mga iba pang mga records, public naman po yun, pwede po yun ma-access if ever.
That's true. Even if the Quadcom or the government of the Republic of the Philippines refuses to cooperate and provide evidence, these are public records. These are video clips. So unless they can show that these were splies or these were fake news, it will be relevant, and the court will look into it. Of course, he will be given a chance to explain his statements there, but to an impartial and objective and intelligent court, hindi na ubra yung joke lang yan, joke lang yan. So serious matters, siguro dito sa Pilipinas, sa mga vloggers, sa mga politiko, sa mga spokesperson niya, pwede nilang gawin yun. Nasabi tayo sa mga ganyang palusot But in other courts, I think they'll be less inclined to believe na joke lang mga ito.
Attorney, I've also heard some arguments that sinasabi ng mga iba na possibly gawin daw ni Attorney Kaufman on behalf of President Duterte that he will maybe try to argue that these policemen had the free will to do what is right because being an officer daw and a gentleman, they should have discerned a rightful order and a wrongful order. So therefore, they will say there's no documentary evidence daw that will directly say na utos mismo directly ni Pangulong Duterte, but rather it was rhetoric daw. So they might pin it on the people daw on the ground. What are your thoughts on this, Attorney?
Well, that's a possible defense track, no? But we have to understand the charge is not murder by direct participation. Crimes against humanity by murder by his direct participation. It says by his as an indirect co-perpetrator. So hindi naman nila sinasabi siya mismo. So this may be material and relevant, but they don't carry that much weight. What is important is that what was the effect of his statements, and more telling would be why did he not lift a finger to have all of these EJK cases investigated and prosecuted properly. Medyo mahirap niyang explain yan. Of course, that's the beauty of a trial.
Yes.
He'll be given a chance to explain whatever he said and why he did not do these things that were supposed to have been done if you as president and commander-in-chief and mayor were in charge of things happening because crimes were being committed left and right. They're not isolated EJKs. It was happening all over. Plus mga public pronouncements niya. So, it's not that easy to convince the court to totally disregard these things.
So, Attorney, yung case against former President Duterte, would this be the same cases that si Senator Bato would have if ever he is issued an arrest warrant? Would they be tried separately or parang conspiracy na talaga ito na pareho silang same evidence ang gagamitin against them?
Well, most probably similar evidence to a great extent. But the charge will be the same. If you look at the warrant of arrest, there are many other top-ranking police officials and government officials who were co-respondents, and they just redacted or blacked out their names for security and practical reasons. So I presume that if and when warrants of arrest will be issued against these other persons whose names were redacted in the warrant of arrest against ex-President Duterte, it will be for a similar offense.
Okay.
There might be a few details that would be different, but basically, pareho lang yan. Titignan din siguro eventually ng prosecution and the court if any one of them would want to turn witness for the prosecution to save his own skin.
Lastly po, attorney, kasi sinasabi nga po doon sa ICC documents in the website, you will see daw po that there are other 9 individuals that are tagged perpetrators po dito sa kasong ito. And most probably, kasama daw po dyan yung PNP chief, which is Senator Bato de la Rosa and others po, no? Will we be going to be expecting po na the same manner of, let's say for example, nagkaroon po ulit ng mga arrest warrant po dito sa atin para doon nga doon sa other 9 individuals na yon? Ganun din po ba yung mangyayari na dire-diretso na rin sila ngayon sa The Hague, makukuha, or may laban pa po dahil since alam na nila paano gagawin, may laban yung defense na hindi po sila madala sa The Hague?
But I think they will be treated equally because that's the rule of law. Persons similarly situated should be treated equally. So if and when there is a warrant of arrest against them and Interpol against us for the cooperation of PNP and the Republic of the Philippines, malamang ganun din ang mangyayari. Unless, of course, the administration has a change of heart in the meantime, or unless the Supreme Court will issue a ruling in these many petitions filed against the government questioning this process of serving the warrant of arrest and the jurisdiction of the ICC. But so far, the latest indication we have is that the Supreme Court considered the petitions, but they did not issue a TRO.
Yes.
So the presumption of validity and legality of government action so far with respect to helping Interpol serve the warrant of arrest remains. And
Yes.
even in the different, in the legislative hearing,
Yes.
the executive has sufficiently and ably explained the basis for its action. So we would expect the same, barring any very significant about-face in the policy of the executive.
Attorney, last na lang ako before I hand it over to Diego. Yung sa pagbalik po natin doon sa usapin doon sa confirmation of charges, sa hanay po ulit ng prosecution, dito po ba malalaman na natin kung sino yung mga key witnesses na ipepresenta ng prosecution?
And even before that, the defense will have to know. That's the reason why it's not kaagad. Because everybody should be, hindi ho uso sa International Criminal Court, in many courts, and it's also starting in our local courts, hindi na pwede yung taguan ng ebidensya. Yung mabubulagta ka na lang kung sino mga witnesses. So there is transparency, because if you're confident with your case or with your side, you should be brave enough to name who are the witnesses, what are the documents, so that the other side also will have a chance to scrutinize, to check them out, and prepare counter evidence. So this process is all in the spirit of transparency, fairness, and faster pace of justice, para hindi yung taguan ng ebidensya, hindi uso ho yun. Yung thinking kasi natin sa Pilipinas, gano'n. Kasi yung ating experience. But ibang-iba ho in other jurisdictions, more so with ICC.
And finally, Attorney, before we let you go, I'd like to maiba lang ng konti about your statement about saying si Solgen Guevara should be dignified enough and a gentleman to resign. But up to today, he still enjoys the trust and confidence of the President. Do you think even if he still has the trust and confidence of the President, he still should, as a lawyer, give up his position?
Well, that's his call. Yes, as I explained, the question of conflict of interest or incapacity to defend a particular client or a particular point in law is with the lawyer. So, call niya yon. No? We are not demanding that he resigns, but what we're saying is it's also an honorable thing to do, to resign if you cannot really defend your clients. Because ang kliyente naman talaga ng OSG would be the Republic of the Philippines and all its officials implementing the policies and directions of government. It would be unfair also for these high government officials sumunod sa direktiba ng chief executive. Ngayon, kinakasuhan, kina-question sila. Tapos yung kanilang abogado sa batas, by law, the OSG should be the lawyer, hindi daw niya kaya o unwilling siya. So that's just an option. Now, we've heard that Malacanang or the President at the very least said, I'm not asking him to resign. So that's his prerogative also. If he wants to stay in that position and he can live with the internal conflict perhaps or with the inability to defend government in these particular cases.
All right, Attorney, we won't hold you much longer. I know you're a very busy person, but thank you so much for your time. That was former Integrated Bar of the Philippines President Attorney Domingo Cayosa. Thank you po.
Maraming salamat. Good morning to everyone.